The judge signals that Jay-Z's defamation claim against Tony Buzzbee will proceed to trial. A Los Angeles judge was leaning towards allowing rapper's defamation claim against lawyer to continue, but not a related extortion claim. It's your boy Heaven Hollywood. We're back on IE Network. This is the Heaven Hollywood Report, and let's get to it. Can I get a trial? So, according to Nancy Dillon from the Rolling Stone, shout out to Nancy Dillon, using this under fair use, a Los Angeles judge signaled Tuesday that Jay-Z's defamation claim against high-profile attorney Tony Buzzbee will overcome a legal challenge and be allowed to proceed to trial. In a tentative ruling, in courtroom comments during a lengthy hearing, Judge Mark H. Epstein said he believed the question of whether Buzzbee acted recklessly and with actual malice when he named Jay-Z as a defendant in a rape lawsuit last December had enough merit to move forward. The same judge also said he was leaning towards dismissing the rapper's related extortion claim against Buzzbee. At the end of the 2-hour hearing, Judge Epstein declined to make a final ruling, saying he needed more time to digest the oral arguments from lawyers on both sides. Jay-Z first sued Buzzbee anonymously in November, claiming the Texas attorney was shamelessly trying to extort him while representing dozens of plaintiffs with claims against indicted music mogul Sean Combs. 3 weeks later, Buzzbee filed an amended complaint on December 8th that named Jay-Z, whose real name is Sean Carter, as the male celebrity who allegedly R-word a 13-year-old alongside Combs at New York City residence back in 2000. Carter immediately and vehemently denied the allegations and confirmed he was the John Doe who filed the extortion lawsuit. The Jane Doe behind the Grape lawsuit went on to voluntarily dismiss her complaint with prejudice, meaning it cannot be refiled on February 14th. Now, in a tentative ruling, Judge Epstein found that Carter had a basis to sue Buzzbee for defamation after Buzzbee referred to the Jane Doe as an sexual assault survivor in a social media post on November 18, 2024, and then liked a post on X, formerly Twitter, 1 day later that speculated Carter was the John Doe assailant described in the Grape lawsuit. When someone says Doe is Carter and Buzzbee likes it, it's not unreasonable to infer that Buzzbee has just affirmed that he's right, that Doe is Carter. Judge Epstein told Buzzbee's lawyers in a courtroom in Santa Monica, California. He said the post taken together created a triable issue of fact, and that Carter's celebrity status as well as public interest in the case meant Carter had to prove actual malice. The judge said a lawyer's failure to conduct a thorough investigation of a prospective client wouldn't be enough on its own, but if a lawyer expressly stated that clients were being properly investigated and then a lawsuit was filed with an inferior investigation, that could create a different standard. All right, he continues, not having done the investigation, we'd all like one to do is not going to be enough to show actual malice. I know that. The concern I have is juxtaposing that with Mr. Buzzbee's statements that he was not going to bring a lawsuit until he had done a full investigation, Judge Epstein said. I agree this is the hardest question of the case, the actual malice question. If you say, I'm not going to name names until I've done real investigating, and then you name a name, isn't the implication that you did conduct a real investigation? And if you didn't, is it okay? Is actual malice still not satisfied when I'm telling the public I did a real investigation and this guy engaged in child rape and actually I didn't? Judge Epstein said knocking out Carter's extortion claim appeared to be an easier call. In his tentative ruling, he wrote that Buzzbee's 2 demand letters sent to Carter in November made no promises to refrain from going to law enforcement if Carter agreed to pay a settlement. Selling silence as to law enforcement for money is extortion, but there is no promise of silence in the criminal context here, and selling silence for money in the civil context is not extortion. It is a settlement with a non-disclosure element, he wrote. The next hearing in this case is set for March 26. In a sworn statement filed February 10th, Carter said it was no exaggeration that he viewed Buzzbee's promise to name him in a grape lawsuit if he didn't mediate the dispute an existential threat to his reputation, career, and family. So we're going to find out on March 26th. It looks as though the defamation case is going to go ahead to trial, but it seems as though right now he's looking to probably toss the extortion. So we'll find out on March 26th, but as of right now, the defamation case looks like it's going to be heading to trial. It's your boy Evan Hollywood for the IE Network. Please like, comment, subscribe, share the video with your friends. Let me know what you think down below about Jay-Z's defamation case. Looks like it's moving forward, but his extortion case looks like it may be tossed. And the reason for that is Buzzbee never said, okay, if you pay me, I won't go to the cops. That would be extortion. And he never gave a formal amount. If you give me this, and this, I won't, you know what I mean? I won't say anything about the lawsuit or whatever. So we're going to find out whether this is going to move on or whether it's going to get tossed. But it looks like the defamation case is moving forward. Talk to you later.